It's the Clay and Lorraine Show on KMOVE.
Welcome to KMOVE Radio, radio for people always on the move. I'm Lorraine Carasosa, here with Clay Goodman.
And today our guest is Cris Vaughan of Vaughan Associates Law Office as we continue our series on abuses of the ADA Law Act. Cris has focused his practice on protecting and defending both public and private businesses and entities with Americans with Disabilities Act, matters as well as related to state and federal laws regarding the accessibility for the disabled,
Yes.
which we support.
Yes, so he's going to give us a lot of information.
Yes. Without further ado, let's go get some good advice from Cris Vaughan.
Sounds good. Welcome to KMOVE Radio, Cris.
Welcome aboard, Cris.
Thank you. Happy to be here.
Well, you know, Cris, we probably have listeners. Actually, no, not probably. I know that we have listeners listening in right now who probably just found out about their business being sued. What should they do immediately?
Good question. Let's start with that one.
Well, the first thing that's so important and sometimes gets overlooked and can't stress enough that they have to do something. This is not a this is what some people would term a scam, but it's a legally authorized process, and they have to take it seriously. They have to get help with figuring out what to do and how to do it, and that's where two kind of professional types come in. The first would be an attorney who is experienced in this kind of litigation, and there are only really a handful in California. And then second is consider using a certified access specialist, which is abbreviated CASP,
Right.
who are people certified by the state of California to provide information about what alterations or changes need to be made on the property for the property to be considered accessible under federal ADA law and the California Building Code.
Okay. All right.
Wow.
So how many of these cases are there in California a month? Are there a lot?
I can't give you a good number in terms of the whole state because it's hard to track them in state court. There are
Right.
two courts where these get filed. Federal court, which is United States District Court. There's 4 federal districts in California. Those are pretty easy for us to track, and I can tell you that there are more than 4,000 of these cases a year that get filed.
Wow.
And approaching 4,500 cases for 2018. We just as part of our ongoing business practice and development, we monitor those filings, and based on the numbers that we compiled at the end of last year, it was almost 4,400 cases filed in federal court alone. We know there are a number of cases filed in state court because we get hired or retained to assist with those either on the attorney side or the CASP side, since I'm both an attorney and a certified access specialist, or CASP, as far as I know, the only one in the state. So we get called on state court cases. So we know there's a lot of them out there. We just don't know how many.
Yes.
Wow.
Yes.
Keeping you busy.
Yeah.
So how expensive I bet. How expensive are these cases? I know it's, per case evaluation, but what's the average?
Yeah, we've had local businesses, especially minority businesses, that are going out of business because
Right.
it's expensive.
Yeah, in the time that I've been doing this, which is approaching 20 years now, we've had anywhere from 10 to 15 businesses go out of business while we represented them because they couldn't afford to defend the cases. So the cost components, as it were, once business is sued for allegedly not being in compliance with ADA disabled access requirements, the cost components would include the defense attorney cost. It would include, if the person who was sued decided to do that, a CASP inspection and report. Attorney's fees can range anywhere from $5,000 on up. CASP report, depending on the property, may be as much as several $1,000s, although they are typically less than that, depending on the size and the number of issues. The real kicker that people don't understand is what they have to pay to the person and the attorney who sued you. they have to pay both attorney's fees of the person who sued you and their cost, as well as what's called a statutory damage under the California Unruh Act, which is the California Civil Rights Act. So they have to pay those damages as well as attorney's fees to the person who sued you. So at least frequently tens of thousands of dollars if you're sued for this kind of a case.
Wow.
Okay, so I'm going to ask a dumb question
Please,
here. So,
beat me to it.
so what are statutory damages?
Yeah, it was Lorraine's turn to ask the dumb question. What are statutory damages?
So statutory damages is a label, and basically it's a label that we use and a number of attorneys use just to describe the type of damages. It's important to understand in responding to that question that no damages are available to the person who sues you under federal ADA law. The only remedies available under federal ADA law are an injunction, which is an order from the court to fix the things, and attorney's fees and costs for the person who sued you. The damages to the person who sued you, or money to the person who sued you, only arises under California law, and that law is called the Unruh Civil Rights Act. It's contained in the Civil Code statutes of California, and that statute, in just a couple of sentences, and it's a real oversimplification, says thou shalt not discriminate in California based upon, and then it has categories: race, gender, sexual preference, and one of which is disability. Wow. So if your property is not in compliance with the disabled access requirements of federal ADA law and the California Building Code, then the statute says for each event or occurrence of discrimination, it's a $4,000 statutory damage.
We've heard that, yes.
Right, and that damage amount, the courts have interpreted it to mean each visit to the property.
Right.
And that's why you will see in cases that are filed 7 or 8 visits.
Yes.
Because the plaintiff and their attorney are trying to stack or multiply that $4,000 damage. Now, there's several ways to reduce those statutory damages that we can go into if you want. It's a little detailed, but we can do it fairly quickly. But the statutory damage under California civil rights law, $4,000 for each visit to the property, as well as an additional $4,000 for what's called a deterrence damage, because the statute allows for an additional damage if you did not go back because you knew it was not accessible, and all of the lawsuits that we see in federal court make that allegation. So even if it's one visit, you're talking about $8,000 potential statutory damage.
It's almost like a la carte damages. Yeah. My goodness.
Let's come back to how you can reduce the visits, because that's what really hurt our little local Mexican restaurant, because they said 4 times and it was only once. So I'd like to hear that, but let's pull the truck over for a quick little truck stop.
Sounds good.
And we'll be right back with Cris Vaughan and find out more about this interesting subject we got here.
Handcrafted, top shelf, local, California, owned and operated. Won multiple industry awards. Best combination for mixed drinks. The one and only Diamond Glacier 33 handcrafted vodka. Check it out. 33belowspirits.com. And be sure to sip responsibly. And welcome back. You are listening to KMOVE Radio. We have special guest today, Cris Vaughan, attorney at Vaughan Associates Law Office.
Yeah, so Cris, please go back and explain to us how they can reduce or eliminate these statutory damages, whereas you said they stack up the visits and hit our local businesses for $4,000 a time.
Sure. It's important to understand how this part of the law came about. There have been numerous efforts in the California legislature, as well as in Congress, to modify this law so that it's not quite as onerous to small businesses. The most recent effort in Congress was in the last session, where a bill, House Resolution 620, actually passed the House that said if you're going to sue somebody for disabled access under ADA law, you have to give them a 120-day notice, they have to respond within 60 days to tell you what they're going to do and then fix it within another 60 days. So the whole concept of notice and opportunity to cure is how that's kind of labeled. Unfortunately, while it passed the House of Representatives and Congress, it didn't even get a hearing in the Senate. And there have been probably, my estimate would be 20 to 25, if not more, bills in the California legislature to do something like that. So the statutory damage issue is what the legislature and the governor have chosen to focus on, and so they have tried to limit somehow how much money a person can get for bringing this kind of lawsuit. Now, it's not the attorney getting paid, it's not the property getting fixed. We're talking now about the person who files the lawsuit.
Right.
Wow.
So there are about 4 to 5 ways to reduce those damages, and I'm going to go through them really quickly. And if any of your listeners need more information, they can contact me, and I'll be happy to, or somebody from my staff will be happy to.
And Lorraine's going to put that on our website, et cetera, and all our social
Right,
media
your contact info.
Yeah.
We're going to go through this fairly quickly. All right.
Okay.
So the most common way to reduce statutory damages is to qualify as a small business, which is 25 or fewer employees, annual gross receipts for each of last year of $3.5 million or less, and fix all of the items claimed to be in violation of disabled access requirements within 30 days of the lawsuit being served or delivered.
Okay.
So again, in summary, small business, fix it within 30 days. Statutory damages under that circumstance go from $4,000 to $2,000.
Oh.
Okay.
All right.
That helps.
Per visit,
Okay.
right?
Okay.
Same standard applies in terms of how many times. Now, let me make just a little bit of a sidetrack here. The history is the most usual number of damages that a court would award would be 1 to 3. So 1 to 3 times whatever statutory damages are.
Mm-hmm.
There is a case in the Northern District, California, which is San Francisco, Oakland, San Jose Bay Area. It was either 12 or 13 statutory visits were awarded. It's a very unique fact pattern, but the most common throughout California, including the Northern District, is 1 to 3 times statutory damages. So we just covered small business exception, 4,000 to 2,000.
Mm-hmm.
There's also an exception that says if you've had a CAS report, again, Certified Access Specialist report, and you fix the barriers that are alleged to be barriers to access in the lawsuit within 60 days, then the damages go from 4,000 to 1,000.
Whoa.
Okay.
But the critical piece there is that CAS report has to have been, or CAS inspection has to have occurred before the person claims they went to the property and it was not accessible.
Okay.
And you have to begin the work, okay?
Good.
So that's the second. 4,000 to 1,000 if you've had a CASP inspection, started making the work, started making the repairs or alterations, and finished them within 60 days of the lawsuit being served.
Okay.
The next change that the legislature made was twofold. The first, I'm going to talk about presumption of no damages, and then the second is going to be no damages by statute. So the presumption of no damages is based upon 7 what are called technical violations in the law that passed became law in 2016. And those technical violations are things like the color of the striping, the order that the words are on the sign, those kind of things.
Okay.
So the problem is twofold. Number one, you have to fix those things within 15 days, and number two, they're very narrowly drawn, so that's hard to qualify as a technical violation. And then number 3 point, I guess, would be that even if the lawsuit includes a technical violation, if it includes other violations besides a technical violation, you're not going to get the presumption of no statutory damages.
Okay.
Oh, wow.
So to summarize that, if you have technical violations only, like color of the striping, there's 7 categories of technical violations. If you have one of those, and those are the only things you're sued for, and you fix them within 15 days, there is a presumption of no statutory damages, which means they have to show evidence that there were damages. It's not just assumed there were because these barriers were there.
Right.
Okay.
So that's the presumption of no damages, and now we're going to go to the last one, which is no statutory damages. a little technical, and we won't have time to go into all those details, but in summary, if you have a CASP inspection, and the timing is an issue there, it's usually before the lawsuit's filed or you have some notice of a violation. You have a CASP inspection. The CASP inspection is a particular type. For example, posts a notice on the property of an inspection, gives a notice to the Division of State Architect of the State of California, and you fix it within 120 days, then there's no statutory damages. And the significance of that, obviously, is to eliminate one of the two pieces that add to the money that it costs a person in terms of paying the person who sued you. No statutory damages, but you would still have responsibility for attorney's fees and costs in that situation. And we've handled one or two of those successfully where no statutory damages were paid, but attorney's fees were still paid. But if you eliminate $4,000 to $12,000 of the amount that you have to pay to the person and their attorney who sued you, it's a significant amount.
Oh, yeah,
okay.
definitely.
Right. Well, thank you. So, Lorraine and I got involved in this, as we said, because of a local Mexican family restaurant that's been in business for 18 years, and now they may have to go out of business. And our last show, we had Julie Griffiths from Citizens Against Legal Abuse, so that's close to what they were. And she told us that there's a case now against these people who are suing small minority businesses in particular, that under an act of this has to do with racketeering, that because these people are abusing these ADA laws to their own benefit. Right. And there's a case, Julie told us, that may be coming up in San Jose against a law firm called the Monroe Law Firm, and it might even include a fellow named Scott Johnson, who's notorious in this area for what many people consider racketeering. Right. What do you know about this case, Chris?
I think there's a couple of corrections I need to make in terms of your statement.
Okay, please.
Great.
The law firm that I'm aware of that's the subject of this kind of a lawsuit is called a RICO, Racketeering Influence and Corrupt Organization Act violation. Yes. Is the Moore Law Firm, Moore, who are based in San Jose.
Right, that's it. I'm sorry.
So it's Moore Law Firm. They are not the law firm that represents Scott Johnson. They represent other plaintiffs, one of which was a gentleman by the name of Ronald Moore, who is the brother of Randy Moore, who was, at least, I don't know if he still is, part of the Moore Law Firm.
Okay. Thank you for the clarification.
The brother of one of the attorneys in the law firm was the plaintiff. And this case is actually filed in what's called the Eastern District of California, which essentially is the Sacramento area down through Bakersfield. And that case is actually in the Fresno division of the Eastern District. And it's scheduled to, my understanding, is scheduled to go to trial sometime in early 2020. Oh. And generally, the allegations, as I understand them, are that it's some contention that they were abusing the law in terms of either not being disabled or not having the types of disabilities that were claimed, or not having the impact or discrimination type effect that they're claiming. So far from knowing much about the case, other than that it is still moving forward to a trial date sometime in 2020, and that it's certainly going to be an interesting case to follow and has potentially large consequences for this whole area of litigation.
Yes. So we're going to follow that. I'm a little disappointed it's so far off. I was under the impression it might be coming up sooner than that. So we'll follow it too. And if you hear anything more about it, Chris, we certainly appreciate you letting us know. We've got some other people as well that are going to let us know about this, because we'd like to follow that. Because we're going to say this, we couldn't say it enough. We totally support Lorraine and KMOVE Radio, ADA laws and regulations. In fact, we're going to have a show with Jeremy and Molly Hale of Ability Productions. They're going to talk about, Molly's in a wheelchair and why these laws are important. So it's not about that, but we are very upset about what has been called racketeers abusing these laws for their own personal gains.
Right, absolutely.
So we're going to follow that closely.
Well, I do think that the statement that I sometimes use, which I think is accurate, is in certain circumstances, it appears that people are using a well-intended law for personal gain.
Right.
And one would think that if that is the case, that there could be some changes to the law, but that hasn't been the case so far.
Right. And so, and I think we want to follow up on that as well. We reached out to a couple of our local politicians here,
right?
Assemblyman Lowe being one of them, and we haven't got any responses. So I think this is kind of one of these issues that maybe they don't want to go there.
Yeah.
Well, you have to understand a couple of things, and I think it's important for everyone, your listeners, as well as people who might be defendants in these kind of cases, to understand the context just a little bit. The ADA law is essentially a civil rights law, and as a result, it is considered as important as if it were a law that prohibited someone from excluding people from their business based on race or gender or anything else. So it's a significant law. It's a civil rights law, and as a result, it is taken seriously by Congress and by the courts.
And it should be. We support that.
Of course.
Yes.
Of course. And the other point that is sometimes lost in the discussion is that when Congress passed this law back in 1990, and the first President Bush signed the law, the law essentially provided for the enforcement mechanism for law to be private lawsuits. And so the courts and business community is faced with the civil rights law, and the mechanism that Congress elected in the law was private lawsuits to enforce it. So that's lost in the discussion sometimes. The second thing that's lost in the discussion is, from the law that Congress passed, the person who sues you gets no money. They simply get made whole in terms of their attorney's fees being paid, so that there are attorneys that would step in and do these kind of cases, but the person who sued you under federal law gets no money. It's only California law where that money comes in. And so those are several subtle points that sometimes get lost in the discussion, and it's important to understand the context these cases are happening. Primarily, that's the way they get enforced by the law Congress created, and Congress didn't seek to reward the individual who sued. They simply wanted to encourage people to be able to hire lawyers, because a lawyer would be compensated for their work if they were successful. And then California law on top of that is where the money comes in that goes to the person who actually...
Okay, thank you for clarifying. So it's only in the state of California where these people that, have become infamous for suing get the cash.
I think there's a handful of states.
Okay.
My belief is it's 2 or 3 or 4.
Right.
California being one.
Okay, and then that's where the abuse come in, and the racketeering phrase comes in.
That's the contention.
Right.
That's the contention that it's the compensation motivation of the person who's suing.
Yes.
That is what's driving these number of cases. The statistics that I hear, and it might be of interest to your listeners, that California has, I've heard, either 12% or 18% of the disabled population in the United States, and more than 40% of these lawsuits.
Wow.
Yes.
That gives a little bit of perspective of the nature of this litigation in California. I know, for example, in Florida, there's no damages that go to the person who sues. They have a large number of cases, but it's primarily because they have active advocates who want to have the law enforced, and so they retain attorneys, and attorneys file lawsuits, but the person who actually brings the lawsuit, to my understanding, in Florida, does not personally get compensation under a law similar to the California Unruh law that provides damages to the person who actually brings the lawsuit.
Okay, yes, that's the rub. So when Lorraine and I first heard about that, we heard these people, their stories that some of these people are becoming multi-millionaires and suing this, and none of the money is going to the people that might need it who are disabled.
Right.
I mean, if it was going to a charity that help people afford wheelchairs, et cetera, then we have a whole different story. But that part of it, that people are taking advantage of it, really upsets us. So,
well, by way of example, there's approximately 200 cases a month of this type filed in the Central District of California, which is Los Angeles County and the 6 surrounding counties.
Yeah.
So 200 of those cases our statistics indicate that one law firm files between 100 and 150 a month. So
one law firm.
That gives you some idea.
Yeah, the abuse. Yes.
The frequent. Well, I can't say abuse. I can say the frequency. Right?
Yeah, there you go.
So,
All right, I understand.
These cases, but
Yeah.
it
Rain
can
can
be
say abuse.
characterized differently by different people.
All right, Cris.
Wow.
Wow. Well,
a lot of info.
A lot of
Great
info, and I know there's a lot of small businesses going to be listening.
Yes.
And so, if they want to get a hold of you, what's the best way to contact Cris Vaughan and the Vaughan and Associates Law Office?
Mm-hmm.
Well, we have offices in Sacramento area, in the Bay Area, and in Los Angeles. They can find us online as well. ADALegalDefense.com is one way. ADALegalDefense.com.
Okay.
They can also search for Vaughan Associates online. The Bay Area number is 415-492-2854.
Okay.
415-492-2854.
And we're going to put the link to your website, too, because that's a great website. You have videos of things you should do if this happens to you. It's very, very informative website.
Mm-hmm.
So,
right, and I think that's the important thing is get informed.
Yeah, absolutely.
Right.
Once you become informed, you can make good decisions about what the right thing is for you, because there's not necessarily one size fits all, but it's really, really important
Okay.
to
Right.
take these seriously and to move forward on them quickly, because as we talked about, if you only have 30 days or 15 days or 60 days to fix it, you need to know that and know what you need to do as soon as possible in order to comply with those deadlines to try to reduce the amount of money the case will cost.
Absolutely. Before we leave you, Cris, could you spell your first and last name so we make sure that people can find you?
Sure. First name is C-R-I-S.
Okay.
Last name, V as in Victor, A-U-G-H-A-N.
At Vaughan Associates.
Vaughan Associates,
Yes.
Bay Area number 415-492-2854.
Well, thank you in advance for the help and for all this good information.
Sure, and we are open to provide some initial feedback to anybody, a free case evaluation. It's not a situation where they should hesitate to call us because it'll cost them money. We certainly provide information at no charge, and we'll discuss the case.
Oh, that's
with them.
great.
So we'd encourage them to get informed and then make decisions. But please don't think this is something you don't have to worry about. It's very important that you act quickly.
Okay. Very
Great.
good. All right. Well, thank you for being our friend, and God bless you. Thank you, Cris.
Thank you. Have a good day now.
You too. Happy New Year.
Bye.
Happy New Year. Bye-bye.
Bye-bye.
And thank you for tuning in to KMOVE Radio. Radio for people always on the move. KMOVE.